Okay, good morning, everyone. I'm Jordan Becker, and welcome to this webinar, which is going to be discussing common myths about intellectual property. We've got about an hour and a half scheduled, and the way we've got it set is to discuss, go through some slides for about an hour, and then leave the remaining half hour for questions, depending upon how long it takes to get through. I may get through earlier than an hour, may have more time for questions. Anyway, so let's get started. And by the way, you can put your questions in the Q&A and I'll go through all of them at the end of the presentation. So let's get started. First of all, you may be wondering, oh, who the heck is this dude? A little bit about me first. So I have a Bachelor of Science in Electrical Engineering. I worked as a rocket scientist at McDonnell Douglas Space Systems for a few years after college in Southern California on the Delta II launch vehicle. Then went to law school in Los Angeles at Pepperdine University. So I've got 30 years now as a patent attorney, and I've obtained more than 1,000 patents for my clients. My law practice focuses on developing and implementing IP protection strategies. And so what I do is I try to get a deep understanding of my client's business strategy and then tailor an IP strategy to their business. That involves basically fighting with the patent office to get them great patents. I focus on largely software and electronics, some mechanical device work and optics as well. And industry-wise, I'm kind of agnostic, but I tend to do a lot of work in the areas of AI, cybersecurity, medical devices, AR, VR, and robotics. So that's a little bit about myself. I would say, basically just technology focused, high tech. So let's get started with some common myths about IP and dispel those myths. So the first thing I'd like to address is the elephant in the room, which is one of the most common myths I hear, and that is that software isn't patentable. It is. And it has been for a very long time. To give you a little bit of history on this, this myth, I think, comes from back in the 1960s and prior, well, not too much prior, software didn't exist much before the 60s, but back in the 60s, it wasn't patentable according to US Patent Office policy. That all changed in the 1980s and 90s through a series of court decisions that made it increasingly clear that software is indeed patentable. You couldn't patent it as code per se, but a reasonably competent patent attorney could easily define a software invention in a manner that is protectable. And that's really the key. Now, some things changed in 2014 when a big Supreme Court case was handed down that we call the Alice decision. It was the Alice versus CLS case. And that made it more difficult to patent certain kinds of software, particularly software that is sort of business method-like software. And so I don't want to get too much into the weeds of that. I could spend an entire hour talking about what kind of software falls under those cases. But I'll just summarize it by saying technical software is easier to patent. Non-technical, meaning you're solving a technical problem. Software where you're not solving a technical problem is harder to patent, but there is no software that is per se unpatentable. Okay, so that's myth number one. Let's go to myth number two, which is copyright is enough to protect my software. Well, the thing to keep in mind is that copyright can be used to protect software, but it's very narrow protection. So copyright only protects the actual expression is the term we used. Copyright in general is used to protect an expression of an idea. In contrast with a patent protects an invention. And an invention can be defined much more broadly than the actual implementation. In the case of software, the implementation is the code. So you can define an invention more as a concept. Now, it can't be too abstract or broad, and that kind of ties into what I was talking about a minute ago with the Alice v. CLS case. But the basic thing to keep in mind is patent protection is much broader in scope and therefore much more powerful to protect any kind of technology, including software. Another reason why copyright isn't that powerful for protecting software is there's no such thing as innocent infringement of copyright. In order to infringe copyright, the infringer has to actually see the copyrighted work and copy it. Whereas a patent can be infringed innocently. So the infringer doesn't have to have any knowledge of the patent to be an infringer, and for the patent owner basically to recover money from them. So in that sense, I would say relying upon copyright for protection of software is probably not wise in most cases. All right, on to myth number 3. I don't need a patent on my invention because I don't plan to sue anyone. Well, this is a pretty commonly held belief, particularly among young startup companies where the idea is we don't want to bother anyone else. We just want to start our business and and sell product. Well, that ignores actually a lot of the important uses of a patent, valuable uses. So, suing someone is one of them. And I would group the uses of a patent into 3 areas: offensive, defensive, and building the business. So in the offensive side, suing someone is basically what it is, or the threat of a lawsuit. But on the defensive side, first of all, a patent can be used as deterrent other operating companies from asserting their IP against you. And so, it can also be used as a bargaining chip for negotiation with competitors, and can be used to block competitors from getting their own patents, which might later be used against you. So a patent, once it is granted, becomes prior art. Prior art meaning part of the public knowledge that's out there, and that then prevents, or at least makes it difficult for people to patent the same or similar inventions. Okay, so that's the defensive uses, aside from the offensive uses. And now what about building the business? So patents are also good for building investor confidence. So patents are really expected by investors. So if you're a startup company, you're at some point pretty early in the life of your company going to encounter investors that expect you to have taken steps to protect your IP, particularly in the patent space. If you're a tech company. Now, this depends upon the level of sophistication of the investors. So, seed stage investors, angel investors may be less strict about what they require. They may care less about it. Their investment is smaller. You start getting into your first venture capital rounds, they're definitely going to expect that you have taken steps to file for patent protection. Excuse me. And so that's really important to do early, to make sure that you've got that in place so you at least look like you know what you're doing. Also, the patents or pending patent applications factor into the company's valuation during a funding round. So aside from it being an expectation, it increases the value of the company. They also help build customer confidence. This is all under the category of building the business. And they enhance the company's reputation as an innovator, so it brings prestige. And I guess lastly, they are concrete evidence of employee contributions. They form some sort of recognition to employees, build employee morale. So all those are really important uses of patents, not just suing someone. All right, let's go on to myth number 4. Once I have a patent, I'm free to make or sell my product without concern. Now, I really hope it's obvious that when I'm voicing these, what I'm saying is actually not true, these myths, okay? I am dispelling these myths, okay? People often think that if you have a patent, that means you are now free to make, use, sell your invention. Not necessarily, and here's why. Now, this is the only I'm going to discuss today where I have some actual slides to kind of back it up. The rest of them, I'm just kind of speaking off the top of my head, basically. But this one, I think, needs some visual explanation. So this, let's say you're thinking of innovating in a particular area, which we call the state of the art. And the state of the art is made up of all of this, what we call prior art. It's just all the pre-existing human public knowledge. That's what we call prior art. And I use this, handy bubbles to illustrate the point, but obviously, they're not necessarily discrete. There's overlap. But to illustrate, now you come along and you develop a product, okay, the green circle in the middle. And you say, I want to protect it. And you engage your patent attorney, and he or she develops a nice patent on the invention. Now, the power to the patent is it can actually protect something that is broader than the product. So he or she can kind of expand out what, from the implementation, what the real innovative concept is, okay? Now, the good thing about that is you can then potentially cover a competitor's product, let's say competitor A in this case, whose product is maybe a little bit different from your product, but they're still using the basic innovation that you came up with. That's great. But now here's the problem, and here's why the fact that you have a patent doesn't necessarily mean you can practice your invention. Because here's competitor B, and they had their own product, and their patent predated your product, right? And they had a good patent attorney that drafted their patent to be just broad enough to cover your product. Could be a different feature in your product. You patented maybe feature A in your product. Competitor B is patenting feature, C, let's say, and your product has feature C in it. Okay, so this is why having a patent doesn't necessarily give you the right to practice your invention, right? And you may ask, well, then what good is it? Well, that goes to the previous myth, and I explained there's a whole bunch of uses of patents, right? That it's a very useful tool to have. I'm just saying that it is not a magic bullet that lets you do everything. What it is a negative right that allows you to stop somebody else from making, using, or selling the patented invention. Okay, I'll say it again. Patent allows you to stop others from making, using, selling, or importing the patented invention. Okay, hopefully that's clear. Let's go on to myth number 5. All right. Patents are always the right form of IP protection for technology innovations. Well, not necessarily. And so, as a patent attorney, I talk a lot with other patent attorneys who, I guess, tend to view themselves kind of as a one-tool person. Where there's an old saying that to a person whose only tool is a hammer, everything looks like a nail. So I actually consider myself to be an IP attorney, more broadly than a patent attorney. And I think that's the right way to practice this kind of law, because patents aren't always the best way to protect technology. Sometimes, for example, trade secret is more appropriate. And there are other forms of IP as well, such as copyright, like I already mentioned, and there's trademark, which I'll touch on briefly toward the end. But those are kind of, trademark is kind of orthogonal to patents and trade secret. Copyright, there's a little bit of overlap, especially in the software area. Trade secret and patent are much more closely related, but they're mutually exclusive. And I'll get into this a little bit more in a bit. Now, how do you decide whether patent or trade secret is more appropriate to protect an innovation? Well, things you want to think about are, for example, how easy is it to reverse engineer the invention, or conversely, to detect infringement in a third party? If it would be very difficult or expensive to reverse engineer your product or to detect infringement by a third party, that is a factor that maybe weighs against patenting and in favor of trade secret protection. And there's no black or white rule here. It's kind of about just weighing all the factors and how they add up, totality of the circumstances. Another factor to consider is the expected life cycle of the innovation. And so if the innovation is going to be obsolete in a very short time. And by short time, I would say, and again, there's no exact line, but probably in less than 5 years, you might want to consider keeping it trade secret, because it would probably take you minimum of a year or two to get a patent, depending upon whether you pay for an expedited examination. It could take 2-3 years, or occasionally longer than that. So if your life cycle of the innovation is fairly long, patents may be more powerful than trade secret. And by the way, it's more a question of whether the innovation is going to have a long life cycle, not the product. Important to distinguish. Remember, earlier in the presentation, I was distinguishing between the product and the innovation, or the invention, right? The innovation may be defined more broadly, significantly more broadly perhaps, than the implementation or the product. And another factor to decide whether trade secret or patent is more appropriate is the strength of patentability and the expected scope you might get if you get a patent, right? So some kinds of inventions are difficult to patent. Let's say in the software realm, for example, I was talking about like business method type software, much more difficult to patent. You might have a long, expensive fight with the patent office. You might end up, if you get a patent at all, with very narrow coverage. So that kind of invention might be more appropriate for trade secret. But it depends upon, is this going to be visible to the public or not? Is it going to be like a back-end process, or is it something you're going to be user-facing? All these are factors that you weigh in deciding whether to use trade secret or patent. And your patent attorney, or IP attorney, I should say, can walk you through all that analysis. All right, myth number 6. I don't have time to think about patents right now. I'm trying to get my product out the door, raise funds, blah, blah, blah. Okay, so I hear this a lot, and I get it, especially with startup companies. They're focusing on what I just said, getting their products out the door and raising funds or bringing in revenue. Well, I guess my answer to this would be, if you think you don't have time to think about patents, you don't have time not to. Patents can be critical, as I mentioned, to getting funding. They can be kind of a prerequisite. More importantly, they're very time sensitive, right? So if you delay in applying for a patent, you could actually lose your patent rights entirely, or cause them to be significantly narrowed. So generally, you have to file a patent application before there's any public disclosure of the invention, or before you start making revenue from the invention. Now, in the US, you do get a 1-year grace period if you yourself start disclose it publicly or start making revenue. But by doing that, you're pretty much blowing most of your foreign or international patent rights. Most foreign countries do not have such a grace period. So strongly recommended to file for patent protection before you have any kind of public disclosure or start making revenue from the invention. Myth number 7, and by the way, I think I've got 15 myths to cover here, so hopefully it looks like I'm doing okay on time here. All right, I'm going to patent the general idea, but I'm going to keep the details of how to do it. In other words, the secret sauce as a trade secret. I hear this a lot. Can't do that. And the reason is because it's what we say black letter law under the patent law, that a patent has to disclose the invention with enabling detail. Okay, that means the patent has to teach the reader, who's assumed to be a person of ordinary skill in the relevant field, has to teach them how to make and use the invention without undue experimentation. Now, what does undue experimentation mean? We don't know until the patent gets litigated. And so the best thing to do is err on the side of being conservative and putting in as much detail as you reasonably can. But we can make judgment calls about this. And I would say most of the time, there's not a lot of guesswork involved when we write the patent application about how much detail can go in. Occasionally, there's a judgment call made. But the point here is you can't hide the ball, right? You really have to teach the public how to make and use the invention. All right, myth number 8. So Joe is part of the team, so we need to name him as an inventor on the patent. Well, not so fast. And this is another one. I actually hear all of these a lot of the time. But everyone wants to give credit to team members who somehow had a contribution to the inventive process. But the important thing to keep in mind is that under the law, an inventor must be someone who conceived of something that's being claimed in the patent. So the claims never seen the patents are legal language that define the scope of the invention. Walk you through this process, but the main thing to keep in mind is just because somebody was part of the team does not mean that they should be named as an inventor. Only if they actually contributed to the conception of what is being claimed is it appropriate. All right, and you can have multiple people. You can have joint inventors. All right, now, a related myth. I'm the inventor, so I own the patent. Well, maybe. By default, yes. That's the law, is that the inventor or inventors own the patent. But that actually changes frequently for inventors who work for companies. So most companies have in place an employment agreement by which the inventors are agreeing to assign their patent rights to the company. And that's very common in my practice. I represent mostly companies, not always. Sometimes I represent individual founders who later form the company, but almost always they want to assign their rights to the company. That typically makes sense to do from a business standpoint. But the thing to keep in mind is that if you're an employee of a company, you probably have an obligation under your employment agreement to transfer your rights and anything you invent to the company. All right. Related myth. I invented it while I worked for the company, so the company owns the patent. Well, as I just said, probably. And that's usually governed by an employment agreement. But not everything you invent while employed by a company is necessarily owned by the company. So, for example, typically and this depends on the wording of the agreement. But basically, most agreements would say that something you invent that is related to the company's business, or that you invent on company time or using company equipment, would presumably belong to the company. So this is something to keep in mind if you've got a little side project going on. You don't want to be using company time and company equipment, like computers, to work on that. And if it's related, fairly closely to your company's business, that could be problematic in terms of if you were planning on starting your own company based on that invention. Myth number 10. Okay, design patents are only for aesthetically pleasing designs. Let's talk about design patents. Actually, let's talk about the different kinds of patents so far. So there are 3 basic kinds of patents: utility patents, design patents, and plant patents. So utility patents protect basically technology, typically. They also protect like chemical, pharmaceutical type inventions. Design patents, I'm going to talk about in one moment. Plant patents protect plants, literally the kind you plant in the ground from a seed. So like Monsanto, for example, is well-known producer of seeds and the like, and has lots of plant patents. Design patents protect the visual aspects of something, and a lot of people think that it has to be something that looks nice to be protectable. Not the case. All that's really important to use a design patent to protect something is that the design itself is novel and non-obvious. Novel and non-obvious are 2 requirements of any patent: utility patent, design patent, plant patent. And so if you've got a visual design, it's novel and non-obvious, you might be able to protect that. Now, examples of the kinds of things that design patents can be and have been used to protect are things like jewelry, furniture, the shape and form of a car or car parts, like the grill on the front of the car. Musical instruments, like the Fender Stratocaster, for example, patented. Clothing, children's toys, adult toys. Now, interestingly, design patents can actually be pretty powerful for protecting computer-related technology. For example, they can be used to protect the form factor of certain consumer devices like smartphones. They can be used to protect aspects of a graphical user interface, or GUI, or emojis, or animations. So, I mean, this may be surprising to a lot of people. So design patents are actually a very powerful tool for protecting certain kinds of technology and shouldn't be overlooked. And they actually both design patent and utility patents on the same product. Now, you can't use design patent to protect the functional features, only the visual aspects. Now, for the functional features, you would use a utility patent. I just want to stay at this point. I am getting messages that my internet connection is unstable. I am hoping everyone is seeing this without a lot of choppiness. Fingers crossed, but hopefully, if there's any issue with that, I get a chat message from our AV coordinator. But apologies if anyone is experiencing any quality issues with the sound or with the video here. All right, so that's design patents. Important to keep in mind as a useful tool to protecting technology. Myth number 11, I have a provisional patent. All right, now this may just be a matter of semantics, but a lot of people say this, there's no such thing as a provisional patent. There's only a provisional patent application. And why that matters is because a provisional application never becomes a patent. It is just a placeholder. What it does is it gets you a filing date and it lives for 1 year. And within that 1 year, you must then file a non-provisional patent application. If you want to get the benefit of the provisional filing date, you don't have to file non-provisional. But no, a provisional patent doesn't exist. It's just a kind of a stake in the ground, basically. Myth number 12. I'll just use my pitch deck as my provisional application. I've seen this many times where startup clients have come to me and they have already filed a provisional application in the form of their pitch deck, and they want to hire me to do their non-provisional application. And, they're pretty confident in that provisional application, and then I have to break them the unfortunate news when I look at that pitch deck that it's just not even close to being adequate. Remember in the earlier slide, I was talking about the fact that you cannot hide the ball when you file a patent application. You have to disclose how to make and use the invention without undue experimentation. So most pitch decks don't satisfy that criterion. They are typically near that level of detail. There's no particular requirement that says you can't file a slide deck as a provisional. You can file a slide deck with Word documents, with hand drawings. It doesn't matter what form it's in. What matters is the substance and the level of detail. So, that's the enablement requirement, as we call it, is the main standard to keep in mind. You can't require the reader to go through a significant amount of guesswork in how to make and use the invention. And remember, the reader is presumed to be a person of ordinary skill in the art. And often the inventors are of higher than ordinary skill in the art. And so you may have to teach the reader a little bit more than what the inventor actually thinks is necessary. That's not always the case, but often. All right, myth number 13. I need to do a pre-filing search before applying for a patent. You don't need to. I would say more often than not, we do not do it. Now, the patent office does a search. Part of the fees you pay when you file a non-provisional patent application are the patent office's services to file a search. And that is not optional. I mean, if you want to have a non-provisional patent application, if you want to get a patent, they will do a search and you must pay that fee. Now, whether you do your own pre-filing search is optional. And I would say most of the time it's not beneficial because you can do, and by the way, I should add that there are reasonable patent attorneys that can disagree on this point. I think the majority would agree with me on this, but there's probably a significant minority that disagree. And I don't have any data to back up the fact that the majority agreed, but that's my sense from talking to colleagues and doing this for 30 years. But you can do a whole lot of searching. You could spend a lot of time and maybe a lot of money paying somebody else to do the searching and not find anything relevant. Doesn't mean it's not there. Patent applications, for example, are held confidential by the patent office at least until they are either published or granted, and they're not published immediately, if at all. Typically, it's at least 18 months from when a patent application is filed until the time it gets published. And so you could do a search today and not find anything, a search for prior art. Tomorrow, somebody else's patent application may get published, which is like dead on killer prior art. So I'm just saying, and besides, people are human when they do searches. So you could do a really good search and just miss that one key patent, even if it's already published. Now, an exception is that young startup companies might want to do a pre-filing search sometimes just to see, if they want to invest the time and the money into, a certain kind of product, if they haven't already gone too far down that path. It might be good to do a quick and dirty search or have your patent attorney do a quick and dirty search just to see if there's anything really close. Larger companies typically have a policy of requiring their employees never to look at patents of any third parties. That raises issues for anybody of potential willful infringement. So if you are ever on the receiving end of a patent infringement lawsuit, and if you lose and are found to have had knowledge of the patent and reasonably believed that you might infringe, the amount of money damages you could end up paying could be tripled at the discretion of the trial judge. And so this is why a lot of mature companies actually have this policy of not letting their employees look at prior art. They also just don't want any potential contamination of their own inventive processes with that of third parties. So this, like many things in legal matters, is a judgment call. And again, in my practice, usually it doesn't make sense to do pre-filing search, but there are cases where it does, and your patent attorney can walk you through that. All right, just time check here. Looks like we're doing really well on time. We're going to have probably a lot of extra time. So I'm going to talk real slow. No, I'm kidding. Myth number 14, patents are irrelevant if I'm going to open source my code. Not necessarily. This is a really, actually, extremely common misunderstanding. The important thing to keep in mind is that open source licenses apply to the code itself, whereas patents, as I mentioned, apply to inventions. And again, inventions can be defined much more broadly than the implementation, which in the case of software would be the code. If you have a reasonably competent patent attorney, they will define the invention. They'll be able to define it more broadly than the actual code. Okay, so while you may publish your code under open source license, you still may have the ability, and it may be beneficial to patent the broader inventive concept underlying your code. Now, many open source licenses require that any applicable patents also be licensed. And I'm paraphrasing kind of an amalgamation of many different open source licenses because there are a lot of them out there, and it depends on the wording, what it allows, right? But many of them would have some effect on your ability or what you can do with patents. Usually they would say that you also have to license any patents you get on the open source code. But keep in mind, you may want to use a patent against a third party who implements the invention, but not necessarily implementing the open source licensed code, the broader inventive concept. So important to keep that distinction in mind. And also, you may want to distribute a non-open source version of your code in parallel with an open source version. So, to that extent, patents to kind of back up the protection of the non-open source version may be wise. You may want to use the patents against someone who breaches the open source license. So you're distributing open source code. Open source licenses are just agreements, and agreements can be breached. They're contracts, right? And so if somebody breaches the contract, all bets are off, maybe. But you at least have the potential to go after them for patent infringement if you've got a patent that covers the broader invention. And finally, you may want to get patents on your code that has been open sourced, at least for defensive purposes, so to deter aggression by others using their patents against you. Okay, so myth number 15. Patents are always the best way to protect technology. So I kind of think I touched on this earlier. You've also got trade secret, copyright, trademark, trade dress, which is closely related to trademark. All these kind of are part of the tapestry of protecting patents. And again, trade secret and patents are mutually exclusive, at least for the same exact feature. I do want to clarify that trade secret and patents can coexist in a given product or system. You just, for different aspects of the system, not the exact same aspect. All right, myth 16, and this is the last one I'm going to cover today. And so just to briefly touch on trademark. So a little background on trademarks. So trademarks protect branding. What they do is identify the source of goods or services for the consumer. And a trademark can be a word, a name, it can be a picture or logo, can be a sound, can be a certain shade of color. The myth is a strong trademark describes the relevant goods or services. Now, marketing people always want, no, I shouldn't say always, I think it's dangerous to use words like always or never, but marketing people frequently like to adopt trademarks that describe the goods or services. And this is easy to understand, right? Because you want to tell the consumers what your product is, what it does, how it distinguishes from the competition. The problem is, from a legal standpoint, a descriptive mark makes for a weak mark. So there are 4 levels of protectability when we're talking about trademarks. The strongest type of mark is called arbitrary or fanciful. And so examples of an arbitrary or fanciful mark would be like Kodak or Exxon for gas, and Apple for computer or electronic products. Arbitrary or fanciful marks say nothing about the nature of the goods or services. That's good from a protectability standpoint, makes for a strong trademark. Okay, the next level, but marketing people often don't like that because, again, they want to tell the consumers what the product is or what it does. So we're constantly having this debate between the lawyers and the marketing people. It's a friendly, gentle debate, but exists nonetheless. And the next level down is suggestive marks. Not as strong as arbitrary, fanciful, but still we call it inherently protectable. Examples of suggestive marks would be like Jaguar for cars, Airbus for airplanes, Netflix for streaming services. Those are suggestive marks. Now, the next level down is descriptive marks, and this is where we get into potentially problematic marks. Descriptive marks, as you might guess, describe the goods or the services, right? So examples of this would be like cold and creamy ice cream or best pizza. So can you get trademark protection for a descriptive mark? Yes. But you have to show that the public has come to associate that name with a particular source of the goods, right? Which if it's your mark, meaning your company, right? And it takes a lot of evidence and time to establish sufficient evidence of that. And so, I wouldn't, say that, never, you can do it, but it's not the best type of mark to adopt, a descriptive mark. And then at the lowest level, you got generic marks, which are not protectable at all under the trademark law. For example, you want to call your product computer or sunscreen or aspirin, not protectable. Those are generic terms. Now, interestingly, a lot of generic terms started off as actual brands. And because the owners of those brands, those marks, did not adequately police those marks, in other words, go after infringing uses, they became generic because the public basically adopted them as generic terms. Examples from history include aspirin, which was a brand name, laundromat, escalator, flip phone. You might even think of some other examples that are technology related that have become arguably generified, which I won't go into. But anyway, so those are the 4 levels of trademark protection. And again, always better to go for the stronger marks from a legal standpoint: arbitrary or fanciful or suggestive, descriptive if you really have to, but not preferred. So that's all I have to present. We are at 9:42, and this is slated to go until 10:30. We have a little more than 45 minutes for questions. And so I'm going to open it up to Q&A now. Oh, and by the way, here's my contact info. Actually, the best way to contact me is through LinkedIn. But you also have my company email there. If you're interested, check out my podcast, the Tech Law Hangout. Talks about the intersection of law and technology. There's lots of stuff on patent law, but also other areas of the law that impact technology companies. You can find it on Apple Podcasts, Spotify, all the usual places that you can find. Let's see. I am going to figure out how I can display the Q&A on my main screen here. Give me a moment, please, to figure this out, because currently I've only got the Q&A on a side screen. Okay, I'm going to go out of slideshow mode here. Okay, Daniel, maybe you can help out with this, because
we'll just stop your sharing. We'll just stop your sharing. It'll be easier for you to see.
All right.
Should be right there at the bottom of the Zoom window.
Yeah, here we go. Okay. 1 second, open up. All right, let's see. We've got a question from Jim F. Creating a derivative work. Depends on what you mean by rewrite. And I'm going to give you probably an unsatisfying answer, very lawyer-like answer, which is it depends. So it's kind of a matter of degree. If you make minor changes to any copyrighted work, that can be considered to be a derivative work. And just for those who are unfamiliar with the terms, making a derivative work is still covered by copyright. So if you don't have the permission of the copyright owner to make a derivative work, then you are infringing by creating a derivative work. But the question becomes then, is the new work derivative work, or is it an entirely new work? it's all a question of fact that ultimately a judge or a jury might be asked to decide. Or you'd have to, kind of talk about with your own lawyer to figure out. There's no simple answer to that. So the answer is yes, rewriting copyrighted code can be, and I would say when you phrase it like that, rewriting copyrighted code kind of suggests that yes, it would likely be creating a derivative work, unless you do kind of a clean room type process where you have somebody look at the copyrighted code and abstract it out into an algorithm that is independent of particular code, and then give that to somebody else who has never seen the code and have them from potentially could get around the issue. Not necessarily a guarantee, but I mean, if you must do it, then that's probably the way to do it. Okay. We've got a question from Michael. How does using open source impact ability to patent? I.e., if I build some new algorithm but use open source technology as part of the implementation, it per se affect your ability to patent. To patent anything, whether it's software or any other invention, the invention has to be novel and non-obvious. And it also has to be patent eligible subject matter, which relates to that Alice case I was talking about. Meaning, I don't want to get too much into the weeds of that, but it can't be too abstract. So the point here is that, yes, you can potentially patent code that you are open sourcing, or where you are using open source code. You can't patent the open source code that you're using, but to the extent you are adding to that, and using it in a larger invention, you can patent that invention. Hope that answers your question. From Jim, in a first to file patent system, is your patent potentially vulnerable to prior documented trade secrets of other companies? If they are documented, then they are not trade secrets. By definition, a trade secret is something that is not publicly documented. So if you're talking about anything that's publicly known, that's what we call prior art. And yes, absolutely. In any patent system in the world, your patent application is subject to the prior art that exists at the time. And typically, most countries, including the US, it's measured from the date you file your patent application. So anything that predates that filing date would be considered prior art. So something that is held completely secret, typically by some third party, would not be considered part of the prior art. But there are also exceptions to that, such as if a company is making revenue from a secret process, then actually potentially that could be deemed part of the prior art, at least for that company trying to patent something. It's somewhat in question whether it would be deemed prior art as to a third party, like you, for example. So I know this is kind of complicated, but the general rule is anything public that predates your patent application is relevant prior art that could impact whether you can get a patent or the scope of your claims if they're granted. Somebody asked, how about board game patents? Not sure what the question is there, but I'll try to read between the line. You can potentially patent board games, but very difficult, like certain aspects, because you generally can't patent a set of rules per se. You might be able to get a design patent on the layout of the board. I would say, I have to say I've not patented a board game, and I have colleagues who have done so, actually. But my understanding is difficult to do, not necessarily impossible. You might get very narrow protection, but probably cannot patent the overall concept of the board game. But this is something you should discuss, with a patent attorney one-on-one. I see that you left me a link. I'm sorry. I will not have time to check that at the moment. Okay, another question. is it possible that a design patent and a copyright overlap? Sure. Well, I mean, you can get copyright and patent protection on the same product or thing. The nature of the rights are somewhat different. As I mentioned, copyright is pretty narrow protection. It only protects the specific expression of an idea. So if we're talking about software, that's kind of the code or something pretty close to that actual code, whereas a design patent just protects visual features. So, well, let's talk about a graphical user interface, right? So you can have copyright protection on a graphical user interface. You can also have a design patent on a graphical user interface. And the thing about the design patent is that protection can be broader, right? So the copyright on a particular GUI screen would only protect that screen. And so what constitutes a derivative work of that is probably pretty narrow difference from the actual copyrighted screen. But a design patent on that same screen potentially can cover much broader variations upon it, only limited by the prior art, right? You can't bump into the prior art that's around you, but as long as you're not overlapping with that, you can expand the scope of protection using a patent until you bump up against that prior art. Please explain filing a feature for the wildly used thing. This is from Lena or Lena. Please explain filing a feature for the I think this is supposed to be widely. It says wildly used thing. I don't understand the question. I'm sorry. If you can retype the question, I'll try to address it later. Can you briefly summarize the process of engaging an IP attorney for a startup? Sure. You contact the attorney through whatever channel, whatever contact info you have made available, and you generally have an initial consultation, telling the attorney kind of what your business is and what you're trying to protect. I like to ask a lot of questions about what the potential client's long-term business goals are, like both near-term business goals and long-term goals, and see if it makes sense to engage on both ends. And if so, again, what kind of protection is the most appropriate? Is it patent? Is it trade secret? Or is it a combination of those? Is there, trademark protection we want to consider as well? So, once you decide on both ends, it makes sense to move forward. You typically sign the attorney's engagement agreement saying, okay, there's an attorney-client relationship. You move forward. I guess it's kind of a vague answer to the question. I mean, if you have specific questions, we can try typing it in and I'll try to address it. Check your chat. Post several questions on the chat. Okay. I'm sorry, I cannot, I'm not supposed to use the chat, just the Q&A. So if you posted questions in the chat, please repost them into the Q&A. All right, let's see. Anonymous says, thank you for presenting. Great. Okay, I unfortunately had to miss much of it. What were your 16 points in brief? Sorry, I can't go through. Let's see. Nah, I'm afraid I can't go through the whole presentation again, but there will be a recording available of this presentation afterwards. That answers the next question. Is a software patent even worth pursuing? Yes. I wonder if you heard my discussion of the what patents can be useful for at the beginning. But again, there's offensive uses, there's defensive uses, building the business, including it's pretty much an expectation among investors that you're going to pursue a patent, whether you're a software company or a hardware company. I think that perhaps more importantly, your competitors are likely going to be pursuing patents. I mean, software. I understand that there is a large portion of the software community that is anti-patent. For 30 years, I've been doing this, and I've been focusing, I would say, more than half of the work I do is software related, just because that's where the demand is, not because I particularly, only want to do software. But So I'm kind of familiar with this, and I can tell you that more people who are developing software are pursuing patents than not. And so if you're not, you're putting yourself at a disadvantage relative to your competitors. I always thought pre-filing search was done to determine if it's even worth applying for a patent. No, pre-filing search is not typically done. I would say it is certainly done sometimes, but in my experience, typically it's not done. But there's no absolute rule on this. Again, it probably is more likely to be done for a very young startup company, or like a couple of founders first starting out, but even then, not necessarily. And this is something, it's very fact specific, and it's a cost benefit analysis. So it's something you want to talk about with your IP attorney. What does it take to protect a granted patent in terms of time and cost? Any technology examples would be great. What does it take to protect a granted patent? I don't fully understand the question. So to protect a granted patent, I'm not quite sure what you mean by that. But if you mean to enforce a patent, maybe that's what you mean. If not, put this, in the Q&A, please. It can be quite expensive to actually sue, once you get into a lawsuit. But typically, the biggest value in patents is really the threat of the ability to sue, and very few patents, even that get threatened with, are actually enforced. But yeah, I mean, it can be in the multi-millions of dollars to actually go through a patent infringement lawsuit. The vast majority of lawsuits settle before they go to trial. But again, I would say most of the value in a patent is not just in the ability to sue somebody. So again, go through the recording if that wasn't clear the first time, and hopefully it will be. And I'm also happy to discuss this offline with people if you want to contact me afterwards. What are the different scenarios where patent applications can be speeded up? Oh, that's a really good question. So yeah, so I mentioned typically a patent application takes anywhere from 2 to 3 years from the time you file it to issue as a patent, but you can speed it up, and there are several ways to do that. The easiest way is just to pay the patent office more money, and for a very small startup, the extra fee is $1,000. For a startup company that doesn't meet certain requirements for being like small enough, it's $2,000, and for a big company, it's $4,000. What that does is it gets you a first answer within about 6 months, and often you can get a patent within about a year. Excuse me. And the nice thing about speeding it up, it's called track one, by the way. This is just one of the possible ways of speeding up. Track one actually, in my experience, and I don't have data to back this up, but just kind of anecdotally, it seems like you're actually more likely to get granted a patent, slightly more likely, by going through track one. There seems to be a higher success rate. And there's a pretty high success rate overall for applying for a patent, but I'm saying getting a patent early in the process. Usually you have to go back and forth with the patent office. They reject it typically the first time. That's normal. They're basically just saying, tell us why you deserve a patent and narrow your claims a little bit. So that's the usual process. We negotiate with them. And what I'm saying is with track one, I find that they're more likely to allow it on the first shot or after the first amendment, rather than making you go back and forth a bunch of times. But it's not a huge difference either. There are other ways of speeding up the process, which is, for example, if you've got an inventor over age 65, certain inventions related to climate technology qualify without extra fee to speed up the process. Anti-terrorism related inventions are another category. There are a couple other minor ones that don't fit a lot of examples. Or if you do a pre-filing search, which is not, and submit a detailed analysis of the search results and pay the extra money, I don't recommend that, because legally, it's not prudent to put a lot of characterization of the prior art on the record with the patent office, just for the sake of speeding up the examination process. So those are the major ways. And track one is by far the most popular. Just pay the patent office a little extra fee and vastly speeds up the process. I often use that with startup companies where it's important to get a patent in process and ideally issued for investors, interests. Okay. I've heard that if you narrow your claims, there is a greater chance of receiving a patent. Absolutely. For example, filing a patent for automobiles versus filing a patent for the Honda Accord. Can you explain how you would counsel clients on narrowing their claims? Yeah. So this is, I would say, probably 95% of the time, that's exactly what happens. You apply for a patent. Your patent attorney drafts your claims to be as broad as they think they can be in view of the known prior art. The patent office comes back and says no. And again, that's not a final no. That's just them saying, prove it, tell us why you deserve a patent, and narrow your claims down. They do their search and they cite a bunch of prior art saying, see this prior art here, this shows your invention, or it shows your invention would be obvious. So then you could respond by just arguing with them and telling them they're wrong. And sometimes that works. More often than not, we will amend the claims by adding restrictions to them to narrow the scope. And then the patent office looks at that. They do a follow-up search, and they may come back and allow the application at that point, saying, yeah, you can get a patent on it. Or they may give you a modified rejection. I would say typically you go through 2 or 3 rounds with the patent office back and forth before they say, okay, you get a patent. So it's by far the most common thing is you do, in fact, narrow your claims down. And sometimes this causes confusion and consternation on the part of the inventors, the patent owner, because they forget 3 years later, they think they have a patent on this broad idea, and they forget that they had to narrow it down to get the patent allowed because there was prior art cited by the patent office. And so they call up their patent attorney 3-5 years later saying, hey, these guys are infringing our patent. Can we sue them? And patent attorney says, well, we can't because the claims are narrow now and they don't quite cover that. This doesn't always happen. I mean, but sometimes it does. And then, I mean, it's unfortunate, but I mean, that's the trade-off. If you want to get the patent, you usually have to narrow your claims down from what you started with. Now, sometimes you start with really narrow claims, right? If you get a first action allowance, you maybe claimed it more narrowly than you could have or should have. Most patent attorneys like to start broad and narrow it down, but sometimes there are occasions where we start narrow just to get a patent issued quickly. So that's not unheard of. So Lena has a question. Sorry, widely filing patent for a widely used thing. I'm so sorry, Lena. I still don't understand what you're asking me. Filing a patent for a widely used thing. If it's widely used, if before you invented it, you can't you can't get a patent on something that was widely used or used in public at all before you invented it, because that's prior art. You can't cover the prior art of the patent. If it's innovative, if you are the first one to at least file a patent application on it, or there's no prior art that predates your patent application, and then you can potentially get a patent on it. And if everybody starts adopting it, I mean, that's exactly what you want as a patent owner, is everyone to start adopting your invention, but not before you have filed a patent application on it. Okay. How to make a patent through what, actually? Sorry. Anonymous says, how to make a patent through what, actually? I don't understand the question. Apologies. Eric says, can you describe your ideal client in terms of their preparation for an initial consultation? No. There's no strict requirements for ideal client. Well, for me, people working in technology. Now, if somebody's got a novel coffee mug they want to patent, I'm not going to turn them away. But that's not the highest and best use of my skill set. High tech is my skill set. Probably not pharmaceuticals or chemical inventions, but I have colleagues that work on that kind of stuff. But any software, electronics, mechanical devices, optics, all of that I handle. In terms of the preparation for initial consultation, just be ready to describe, what's your business. If you're thinking of starting a business based upon the invention, be ready to talk about that, and be ready to talk about the invention in some details. Usually in the initial meeting, the patent attorney isn't going to dig too deeply into the details. Usually it's just kind of getting an idea of what is the invention about, and does this relationship make sense on both ends to move forward? Is it a good fit? Is it the kind of thing that you should try to patent? Sometimes potential clients come to me, and I'll tell them sometimes, don't waste your money on this. This isn't going to help you in your business. I wouldn't do it if I were you. I'm not hesitant to say that when I think that. Okay. Are there any common pitfalls in filing for a board game patent or any patent in general? I'm not going to get too specific to board game patents. Again, I think the major pitfall I could think of is that if you're just claiming a set of rules, like the rules of the game, you're going to have a very difficult time patenting that. I would never say never, but it's about as close to never as you can get for just patenting the rules of a game. Specific design, maybe of a game board or game pieces, maybe you could patent. And you would have copyright protection on any original design aspects of that. Patents in general, pitfalls. I've gone through a lot of them already in this presentation. Biggest pitfall for any patent filing is waiting too long to engage the patent attorney. You let prior art develop, and it's not just your own prior art. It's not just your own disclosure that matters, but those of third parties anywhere in the world that could be similar to your invention, or maybe render it obvious that you need to worry about in terms of delaying your patent filings. I'm seeing a bunch of stuff coming up in the chat. 27 messages. I'm sorry, I'm kind of still looking at the Q&A, but if you do have questions, please put them in the Q&A, not in the chat. Just a time check here, 10:07. Good, we still got 23 minutes. I hope this is helpful to people, I really do. All right, so let's see, here's a long question. How to establish trailer to establishing or trailer to a trademark to another party, including a corporation. I'd like to legally license a trade name I've created to other businesses. What would one legally be allowed to do? What are some potential things that mark and patent holders should be careful? This question is a little too involved for me to answer in this context, but if you connect with me offline, I will do my best to address that question. That's from Matt T. What's the ballpark for applying for a patent? Yeah, good question. So depends. For provisional patent application, I would say could be anywhere between $1,000 to $6,000, depending on how much work the inventor is willing to do. So typically for startup companies that are not well funded or not funded at all, we like to do provisional patent applications because they can be done quick and dirty. The reason they can be done quick and dirty, again, is not because they need less detail, but because the form requirements are very loose. You can, it doesn't matter what they look like as long as it has the substance in there, and they don't have to have claims, which is the legal language, like a non-provisional application must have. And so they require less attorney time. So if the inventors are willing and able to give the attorney a nice, thorough write-up of the invention with some good drawings, you can keep that on the low side. I would say the typical range for a provisional patent application is going to be $3,000 to $5,000. Occasionally, it can be less for like simple inventions where the inventors provide a really good write-up, and occasionally it can be more. But usually, almost always, the patent attorney can tell you right up front, what it'll be. For a non-provisional application, which you ultimately will have to file, It varies greatly. It depends if you have a really good provisional application already filed and you can leverage the description from that, then it can keep it on the low end, and could be $10,000 or in that ballpark. Potentially, though, if you're starting off with a non-provisional, it could go over 15. Again, it's case by case. You really need to talk with your patent attorney and talk about more detail, and then he or she can tell you how much it's going to cost. But broad ranges: provisional application, 1 to 5,000, and non-provisional, 10 to 16,000, or sometimes more. Okay. How do you patent the same patent in multiple jurisdictions? Okay, so in the US, patent is a federal right, so you can only get a US patent. You don't get state patents. And patents are country specific. This is a really good question, right? So getting a patent in the US doesn't give you any rights anywhere outside the US. It does allow you to potentially stop someone from importing an invention into the US, okay? But if you also want to protect your invention in China, for example, or in Europe, you have to apply for a patent in China, or in the appropriate European countries. You can also apply for a so-called European patent that can cover most of the countries of Europe, actually, in a bundle. But they're country specific. And in terms of timing, typically what happens is you would file a U.S. patent application. You don't have to. I mean, if you don't live in the U.S., you can file in your home country. But then by treaty, you have 1 year to file in foreign countries. Whether you file in the U.S. first or whether you're filing in some other country first, you then get a 1 year period in which to file in pretty much every other foreign country. So if you file a provisional patent application, then 1 year later is your deadline to file both a non-provisional U.S. patent application and optionally file one or more foreign patent applications. Hope that's clear. All right. Matt says, sorry for the typos. Basically, I meant to ask about legally establishing and licensing trademarks you establish to others for the sake of profit. What legal guidelines, penalties, and pitfalls startups should be aware of? Too much to go into, Matt. Apologies. If you want to connect with me offline, I'll address the pitfalls of the trademark protection here. Okay. We've got a case from EAM, in a case where it was found that a competitor already had a patent for a product similar to my own, but there are multiple other competitors also with similar products, but without their own patents. Is it likely that a patent that the competitor has is undefensible? Okay, let me read that again. In a case where it was found that a competitor already had a patent for a product similar to my own, but there are multiple other competitors also with similar products but without their own patents, is it likely that the patent that the competitor has is undefensible? Not enough facts to answer that, but I can just tell you in general, if your competitor has a patent, first question you would ask is does their patent predate your product, or does your product predate their patent? If your product predates their patent, then it's prior art, and you can't infringe their patent if you predate them. Now, assuming their patent predates your product, then it's potentially a problem. And then you look for prior art to try to kill their patent. And prior art can be other companies' products that predate their patent. The key would be, would those other products, or it could be actually that same company's earlier products, could be prior art to their patent. That happens sometimes. But you'd have to do analysis. Your patent attorney would have to go through an analysis and look at the claims of the patent that you're being threatened with, and see, and look at the prior products and prior patents and all the public knowledge, and see if there's anything that actually discloses everything that they're claiming. It's a pretty involved analysis. Okay. Aremus has a very long question. Aremus, it's a really long question. I'm afraid I can't read that online because it's a bit too long to address. Happy to connect with you offline on that one. Let's see. Next question, is any type of insurance available nowadays covering costs of prosecuting infringement of your patents? That's a really good question. Simple answer is, I don't know. There's certainly, business insurance available to protect you against you being found liable for infringement. But in terms of protecting you against the cost of prosecuting infringement, my guess is probably, there's probably insurance for pretty much any kind of contingency you can think of. I don't know anyone, none of my clients, to my knowledge, have bought such insurance, but it wouldn't surprise me if it's out there. Whether it's going to be cost effective, I don't know, because how likely is it you're going to actually enforce your patents? I mean, most patents don't get enforced, but it's something to keep in mind. So let's see. Is it possible to make a patent online? In fact, that's, if you mean, is it possible to apply for a patent online? That's pretty much the only way you can do it. I think you might be able to still file paper with the patent office, but I don't think we've done it in 20 years, at least. So it is done online. You can do it yourself. I wouldn't recommend it because it's really easy to make mistakes and screw things up. And, as one of my professors in law school once said, you know what you know, but you don't know what you don't know. So you can write a patent application yourself and file it yourself. And there are books out there that will tell you how to do it. And you can get a patent granted. But one thing to keep in mind is that not all patents are created equal. It's not like filling out a form. So you can have 20 different patent attorneys write a patent application on the same invention, and you'll get 20 completely different looking patent applications, which become the patent. And out of those 20, maybe 2 of them are excellent, 2 of them are probably worthless, and the other 16 are somewhere in the middle. And it really depends upon the skill of the attorney. And there's a reason they call this law practice, right? Because it takes years of skill to really get good at this so you can get value. That's the real issue. It's not hard to get a patent per se. It's hard to get a patent that is worth something once you get it. And for that, I would strongly recommend you engage an attorney and not try to do it on your own, but you can do it on your own for sure. And you can do that, online. Okay, let me check time. Okay, 10:17, we've got 15 more minutes. I think we're running short on questions though. So let's see, what should one do if there was prior art documented, done by oneself or one's company, and a patent related to the solution or design is issued afterwards? What should one do if there was prior art and a patent? So it sounds like you're concerned, this is from Edward. Sounds like you're concerned that some competitor of yours maybe has patented something, but that it already existed. If it already existed in the prior art, then if they do in fact come after you, then you can point that out to them, or to their attorneys, or if it comes to it, to a judge or a jury, if you actually go to litigation. But typically when you get threatened with a patent, if you can show the patent owner, hey, look, your patent reads on the prior art, it's invalid, they usually go away if you can establish that. But another thing to keep in mind is just because somebody has a patent where the title is computer system doesn't mean they've patented computer systems, right? I mean, the title is not what the patent covers. So a lot of people get freaked out by competitors' patents based on the title, saying, how can they patent that? That's in the prior art. You have to look at the claims, right? And this is what a patent attorney does all the time, right? And you have to really read and understand what the claims cover. And almost always the claims are considerably more narrow than the title or even the abstract. So don't get too freaked out, if it's just based upon the title. How much should you license a patent for? Wow. I mean, there's no easy way to answer that. How much should you license a patent for depends upon so many variables, particularly the industry that you're in, how broad or how narrow the claims that you got granted are. How what's the the market share you're addressing? What's the cost of the product that's being covered? I mean, there are lawyers who specialize entirely in the licensing aspect, right? So, but even they, I suspect, you're not going to be able to answer this question without a lot more information about what kind of patent, what kind of industry, and other details. If you live in, okay, I'm not going to mention this place, but person's mentioning a foreign country, I need to register it only in your, okay. If I live in foreign country X, do I need to register it only in Europe? This country is in Europe. Well, okay, you don't need to register. Okay, the term is not register, you patent it. I'm assuming you're talking about an invention. Okay, if you live in Europe, you don't need to patent it anywhere. Right? There's no requirement that you patent it. But if you're trying to protect it, you can get a European patent that is then validated in specific European countries. And you would choose the countries that you think are most important. How do you choose which countries you want to patent it in? That's ultimately the question you're trying to ask here, I think, right? So I think the answer to that is look at where are your most important markets, okay? So for most inventions, you would want to try to patent them in the US because that's, if not the largest, then, one of the top 3 markets in the world. Other big countries like China and certain European countries are important in terms of where's your market. You also typically want to try to get a patent wherever your competitors are located. So if they're producing product, whether they're producing code, if they have servers located in a particular country, or if they have manufacturing facilities for a physical product, those are places where you would want to try to get patent protection. There's no per se rule on this, but those are the main factors that I would consider. Do you work with many European startups? Yes, I work with lots of European startups. What is the difference between provisional and non-provisional patents? Again, there's no such thing as a provisional patent, only a provisional patent application. Provisional patent application never becomes a patent. It just gives you 1 year to follow up with a non-provisional application. The non-provisional application can become a patent. So provisional is just a placeholder for 1 year maximum. Let's see, following up to a narrowing question. I have an existing patent expiring in 4 years. The new patent idea I'm developing leverages some of the items in the existing patent and other items tangentially related. Okay. New patent, okay. Is the same narrowing approach you discussed earlier today apply? Okay, you've already got a patent, okay, it's going to expire soon. Now you've got some additional ideas that leverage that build upon that. Then does the narrowing approach apply? Yes, it does. It's the process you go through with the patent office. It is a negotiation. Now, could you get lucky and you claim it, the new ideas, and they just say yes on the first try and they don't require you to narrow your claims? Sure, that sometimes happens. Usually if they say yes on the first try, that means you could have claimed it more broadly. And that's okay. I mean, if you wanted to start off narrow to get a quick patent, then we can file a continuation application to pursue broader claims. So nothing wrong with that. But yes, I would say generally speaking, that narrowing approach almost always applies. Can you please clarify? January 1, 2025, apply for a provisional patent in the US. December 31st, 2025, apply for a provisional patent in the US. What is the deadline for a patent in non-US markets? Really good question. Okay, the deadline to apply in any foreign country is 1 year from your earliest patent application on the subject matter that you are disclosing. Okay, so you file provisional January 1st, you then file and then it says December 31st, apply for provisional patent. I think you meant non-provisional, right? So 1 day short of 1 year, you apply for the non-provisional application. January 1st, 2026 is the deadline to file the non-provisional application and to file any foreign applications. Hope that's clear. Oh yeah, oh, you did clarify that question in your next one. Okay, so who can see the questions? Only me and my tech support guy can see these Q&A questions. All right, we are at the end of the questions that I see, and we are at 10:25. What I will do is hang online for, I guess, 5 more minutes in case any new questions pop up. And if obviously you're free to hang on and listen, or drop as you may wish. But I thank you all very much for joining it, and I hope you've learned something today. Again, you can contact me through LinkedIn. You can also reach me at jbecker@perkinscoie.com. That's PERKINSCOIE.com. Really appreciate everyone taking the time. Okay, so yeah, Ian just asked for my contact information. Hope you got that. Again, if you didn't get the email, then LinkedIn, Jordan Becker, patent attorney. There's more than one Jordan Becker, but probably not too many patent attorneys. Let's see. And I really appreciate everyone staying online. These are really great questions, by the way, really insightful questions too. And this was a lot of fun for me. So yeah. Okay, so I'm gonna hang on for a couple more minutes in case the new question pops up, and here's one. Can a competitor challenge an awarded trademark which sounds generic? Yeah, I mean, trademarks absolutely can be challenged. I mean, there are no IP rights that are set in cement that are, non-challengeable. So I mean, if it sounds generic, most likely it's not going to be granted. It's not going to be registered by the U.S. Patent Office in the first place. But certainly, if it were, then that would be a basis you could challenge it on. Okay, question coming in. Do you personally use AI in writing patent applications? Really good question. The answer is yes, to a limited extent, very limited extent. So currently I use AI to do certain proofreading. There are companies out there that I'm well aware, are working on AI for writing patent applications. They contact me at least weekly asking me to trial their products. The ones that I've tried so far are not ready for prime time. I do think within the next few years, patent attorneys will be using them as tools more and more. I think they will never replace patent attorneys. They may soon reach a point where they can replace very junior patent attorneys on some of the simple drafting tasks. But I am skeptical that AI tools will completely replace human patent attorneys. Maybe this is me being wishful thinking. Not before I retire, I think. But who knows? I could be wrong. I do think, though, that they're going to be commonplace tools in my profession, just the way word processors became, ubiquitous. What's your take on AI assistant of patent application? Okay, so I kind of just answered that question. Lots of questions on AI coming in now. Where did the AI in particular tend to screw up patent application? Oh, this is a really good question. Yeah, where do people screw up on patenting AI? There are 3 levels of protection when it comes to AI. One is patenting innovations in AI, in other words, improvements to the AI itself. The second level would be new applications of AI. And the third level would be patenting things that AI creates. So the first one, innovations in AI, is the easiest to protect, especially if it's technical, but not necessarily. So I would say, in terms of where you can screw up, it's really hard to generalize. Probably not including enough detail in the patent application about how training is done, for example, how you assign weights and parameters, things like that. The second category ties into that, right? Patenting new applications of AI, harder to do, not impossible, but harder to patent than patenting innovations in the AI itself. But if you're patenting a new application of AI, then you may have to focus more on the training and how that's done, like using particular kind of data or how you assign the parameters. You can't currently patent innovations by AI, things that AI itself invents, like computer software generating, something new. Under current law in the US and under most countries, you can't patent that. Hope that answered your question, Alexander. We are at 10:30, I believe, according to my clock. So we are going to stop the recording in the webinar. Again, thank you so much for participating. See you next time.